Chapter 17, Action of Riplevin, Sec. 93. Action of Riplevin, some general requisites. This action was generally resorted to recover possession of a specific article, wrongfully detained from the owner. At common law this action was confined to cases where trespass could have been maintained, 168 where the original taking of the property was in a tortious manner. But the whole proceeding of Riplevin, at common law, is distinguished from that in trespass in this, among other things, that, while the latter is intended to procure a compensation in damages for goods wrongfully taken out of the actual or constructive possession of the plaintiff, the object of Riplevin is to procure restitution of the goods themselves. When the taking was lawful and the subsequent detainer or conversion alone formed the ground of the action, detenue was the only remedy by which goods, in specie, could be recovered. But later, by statute, the action of Riplevin was extended to all cases where goods or chattels had been wrongfully detained, whether the original taking was lawful or unlawful. To render a person liable to an action of Riplevin, it is necessary that he should have had either actual or constructive possession of the goods, otherwise he cannot, it is said, be charged with a wrongful detainer. To sustain the action of Riplevin the plaintiff must have either a general ownership of the property detained, or a special property therein, so as to give him the right of immediate possession at the time of the detention and issuing of the writ. The plaintiff must show that he was entitled to the possession of the property at the time the action was commenced. In all cases where the possession of the defendant was lawful and proper, until demand is made by the plaintiff, a demand must be made before the action is brought. Under the common law procedure, the plaintiff in this action obtained the possession of the goods at the commencement of the action, and it differed from detenue in that the party did not have to wait, as in detenue until the action was determined, before he could obtain possession. This action was regulated by statute in the various states even before the code. There is some ancient history with reference to this action which is of little consequence, except for curiosity. There were two forms of the action, one for the recovery of the specific article, and the other for damages. This is questioned, however, in Fletcher vs. Wilkins, 6 East, 2861,170 where it was determined that there was no mode of proceeding by action of Riplevin to recover damages, as contradistinguished from proceeding to have the goods again. The declaration was formerly known as Riplevin in the Detanet. Riplevin was never extended at common law beyond the case of an original wrongful taking of the goods from the possession of the plaintiff. An attempt was made to broaden the form of action so as to include all cases where detenue or trava could be brought. There was no original writ in its earliest history, the action not having been commenced in the superior courts, but in the county courts. In Ohio, before the code, it was commenced by filing a praesipan affidavit, alleging that the party had a good right to the possession of goods described in the praesipan, and that they were wrongfully detained. A writ was thereupon issued to the sheriff requiring the person detaining the same, to appear and answer for such unlawful detention. The sheriff then seized the property, and could break into any house or other place where the property was concealed, after demand had been made and refused. An appraisement of the goods followed. The defendant could enter a plea, as a plea of on detenet. The action is still regulated by statute under the code, and is commenced by filing a petition. Sec. 94. History of the action. According to Blackstone, to replevy is, when a person distrained upon applies to the sheriff or his officers, and has the distress returned into his own possession, upon giving good security to try the right of taking it in a suit at law, and, if that be determined against him, to return the cattle or goods once into the hands of the distrainer. This is called a riplevine. Replegia, that is to take back the pledge, was the name of the action which proved to be a convenient action for the settlement of disputes between landlord and tenant. It was supported upon the theory that a serious offence had been committed against the king. Under the common law a landlord, without writ or other process, could take the goods and chattels of his tenant and retain them as security for rents due him. If this was done wrongfully, it was considered an offence against the crown, for which redress could be had by the action of Riplevin. The right to pursue this remedy was granted by an original writ of Riplevin, as all other common law actions were commenced. Although the writ originated for the express purpose of relieving against the wrongful exercise of the right of distress for rent, yet it was occasionally pursued in other cases of wrongful taking. Opinions were not uniform among earlier writers, and with judicial precedents concerning the restriction of the remedy to wrongful distresses. Blackstone stated that it was resorted to only in cases of distress for rent. The courts, however, disputed this, stating that Blackstone's conception was too narrow. As the Lord Chancellor said in Shannon vs. Shannon, 1 SEH, and Lef. 324, I am always sorry to hear Mr. Justice Blackstone's commentaries cited as an authority. He would have been sorry himself to hear the book so cited. He did not consider it such. His definition of the action of Riplevin is certainly too narrow. Many old authorities will be found in the books of Riplevin being brought where there was no distress. There were 3 epochs in the history of the action, one form in Glanville's time, the second in Bracton's time, and Riplevin after the Statute of Marlbridge. In its earliest history the injured party applied verbally to the sheriff, who upon having security properly given, proceeded without a writ to make Riplevin. This mode of redress was provided by the Statute of Marlbridge 52, Henry III, to guard against the delay incident to the application to Chancery for an original writ. The Statute of Westminster 2, c. 2, 1285, provided that before delivering the property to the plaintiff the sheriff must take security for a return of the property to the defendant in the event that plaintiff was defeated and a return was adjudged. And later by Statute 11, George 2, 1738, c. 19 the sheriff was required to take a bond with 2 sureties in a sum double the value of the goods distrained, conditioned to prosecute the suit and make return of the property when return was adjudged. Sec. 95. There must have been an unlawful taking. An action in Riplevin was not maintainable unless in a case in which there has been first a taking out of the possession of the owner according to the earliest decisions. In Re Wilson's 177 the Lord Chief Justice stated, the writ of Riplevin is merely meant to apply to this case, namely, where A takes goods wrongfully from B and B applies to have them redelivered to him upon giving security until it shall appear whether A has taken them rightfully. The judges were troubled, however, with the question of the determination of the title to the property. They were of the opinion that the first evidence of title was possession, that you take from the possessor in the first instance, by action of Riplevin, you throw the onus of proving title upon him, on whom, as having the prima facie title, possession, the onus ought not to be thrown. The defendant may have conducted himself extremely ill, but the law has provided certain remedies adapted to certain cases, and upon affidavit made on his behalf, it appears that the remedy is either detenue or trava. It became the rule that to warrant Riplevin, there must have been a wrongful taking of the possession of the owner in the first instance. The theory was that was a general rule. It is just that a party in the peaceable possession of land or goods should remain undisturbed, either by the party claiming adversely or by the officers of the law, until the right be determined and the possession shown to be unlawful. But, where, either by distress or merely by a strong hand, the peaceable possession has been disturbed, an exceptional case arises, and it may be just that, even before any determination of the right, the law should interpose to replace the parties in the condition in which they were before the act done, security being taken that the right shall be tried, and the goods be forthcoming to abide the decision. Therefore it was considered that for Riplevin to lie, there must have been an unlawful taking by fraud or violence. So that in the common law procedure the lines between the actions being tightly drawn, if it developed in an action of Riplevin, that the defendant having possession of the goods, held the same lawfully, as bailey of plaintiff, he could not proceed by Riplevin, but he should prove his prior right in trava or detenue. A writer states, it has been remarked that the action of Riplevin has never been extended by any judicial authority in England to a wrongful detention, distinct and independent of a wrongful taking. A torsion's taking preceding the wrongful detention has generally been regarded as necessary to support the action there. It must be admitted, however, that there are some authorities tending to controvert this proposition. Justice Coleridge, in 1856, holding that it lies only for a wrongful taking in reviewing the authorities, refers to a dictum of Lord Ellenborough in Daw vs. Wilkinson, 2 Stark N. P. c. 287, from which the inference is that he thought Riplevin might conveniently be had recourse to more often than it was, instead of bringing Trevor. The English view that it can only be pursued in cases of original unlawful takings obtained lodgment to some extent in this country. But this was soon pronounced a fallacy, the remedy being universally extended so as to embrace cases for wrongful detention merely.